Okay, why don't we get started and going through it? Now, I'm sure everybody's dying to find out, what am I going to cover next month? Well, this test was long enough on purchases, on sales. So next month, we're going to do leases. Yeah, because we would have been here a lot longer than that. Leases, I find that a lot of agents kind of consider them, not as serious. You have tremendous liability representing a landlord or a tenant. And so we're going to go through that because that's a whole separate process from what we're talking today. But why did we do this evaluation? Well, last year in December, TREC decided to change the broker's responsibility rules. And typically, the rules had always been somewhat broad in their language so that they could use it and wield a sword against any broker at any point in time for any failure of responsibility. Well, they decided to get it down to itemization. So the brokers now have a very different set of values that they have to go through in responsibility in holding somebody's license. And so I've kind of broken it up in categories here, but I'm just going to tell you, it was pretty profound. And the reason for that is when I got my license in the early 1990s, before many of you were born, my broker looked at me and told me I could do any transaction in real estate I wanted. And I'm thinking, I just passed my test. How could anybody say that, right? But that's just kind of how they just gave you permission. That is not the case today. You have to have everything in writing from your broker. You don't step out of a residential transaction without written permission by the broker. You can't do your first transaction in a lease or a listing or a contract without direct supervision by the broker. It's not construed that you're in an employer-employee relationship. In fact, it actually says the exact opposite at the end of the rules. These are very minute areas the broker has authority over you. And the biggest one is they have to determine your proficiency on an ongoing basis. What does that mean? It could be by transaction. So this evaluation is one to help you. What is it that I might not know as well as I would like to? It's also a caution to you. You don't use a form or go into a type of transaction without making sure you're doing the right thing. That's what I'm trying to tell you to help you. Because the worst part is if your broker has adopted rules, and they have, and policies, and then you didn't follow them. Do you know what I'm saying? It'll be on you, and I don't like that. I don't want you to be blindsided by something that you're required to do. Many of you come to the risk management training or you listen to it remotely, and that is great because what I cover here is what the broker can say to TREC. Oh, I've covered that. So even if you're not here physically, but you come in because you link in, that's fine because it's going to cover those areas that we've had concerns over. And we always discuss what is kind of current and what's going on. So again, that's the reason for this evaluation. So the first thing we're going to touch upon is advertising, because I'm going to tell you there are more agents that violate that and they don't realize it. They kind of forget. And our rules changed dramatically for advertising in 2017. And they don't forgive you at all. They don't give you a second chance if you violate any advertising rule. That's been what we've recently felt from TREC on any violation. So it says, number one, I cannot conduct any advertising unless it complies with TREC requirements. That's a statement, one you take to heart and one that you abide by, okay? The next one says, should I contact someone prior to doing signs, cards, emails, and websites? You betcha. You don't get to do anything without making sure it has met approval. That's even on your emails. When I get your emails from you and they are in violation, you don't have Keller Williams anywhere on them, you might have all sorts of stuff, I send that on because that's going to be a broker issue. The broker is going to visit with you regarding those type of things. But make no mistake, it applies to your emails, okay? You're never alone anymore. You always have Keller Williams with you. That's on the bottom of your emails, your flyers, your websites, everywhere. Number two, can I use a title in advertising of president, CEO, or owner? No, we are prohibited from doing that. Trek gave us a wonderful opportunity to understand how we could advertise, and we can only advertise using, we don't even have to say we're an agent anymore. We get the privilege of using the trademark realtor when we're with the association, which we all are. But we cannot, on any advertisement, any website, any flyers, anywhere, ever say that we are the CEO of our team or group, or that we're an owner or the president, because Trek says that confuses the consumer. They think that maybe you are in charge. And so what Trek did for us is they created an ability for us to advertise in a name other than our license name with our brokerage. And that is when we end those names in team or group. We could never, ever have any other name other than our license name that we would use in advertising unless it ends in team or group and has been reported to Trek. Do my emails always need to have the KW brokerage listed? Oh yeah, every last one of you. You're never alone, okay? Where can I find a current list of any and all DBAs for the brokerage? Trek, and I brought it up on the screen. It gives the DBAs for the market center first, and those change all the time. The brokerage could modify or add a DBA at any time. So always look and make sure that whatever DBA you're using for the brokerage, it's here already at Trek. You cannot use any other name other than that. Then below is all the team names and the group names. I had an agent who's been with Keller Williams a very long time, and they said, when I pulled it up for their market center, they said, my group name's not there. Okay, I said, okay, here's what happened. Years ago, Trek didn't even have a form. We sent faxes. Does everybody know what a fax is? Okay, we sent faxes to Trek to let them know the broker gave XYZ team permission to advertise using that name. Okay, so we sent faxes up. And after we send a fax, it would have, make sure you sign in, otherwise you will not get credit for this. And there are the handouts from the test too as well. So anyway, what happened is we would send those faxes up to Trek, and all I kept thinking is, I bet that goes in the trash can pretty often. You know what I'm saying? It was just coming off a fax machine, and this is before they had their website like this and all this type of thing. So I never threw away anything. Those boxes are still in my attic of every receipt showing that we had registered it. But in 2017, what happened is Trek goes, you know, I don't have all those records, which we knew they didn't have the record keeping properly because they tried to find us many times, and we proved, oh, we sent a fax to you on such and such date and year, and we have proof. So the thing is if your name is not here, you need to get your DBA and bring it to the office, and then they'll make sure that it's uploaded and properly placed on the Trek website. That is a big, big issue, and that's one of the things that's coming in. The websites have to be monitored by the office, because if you're not in compliance with not only the completed information about brokerage services or the consumer protection notice being posted, you can get in trouble there as well. Yes, sir. So when you say DBA, any county you use, he asked, he says, do you have to register the DBA? Any county you will advertise in, you must have that DBA filed and recorded there. Here's I think this is working. Let's see if it works. Okay. Yes. Did anybody have a question? You need to come get a microphone. You can't ask a question because nobody at home can hear you.
So if we are on this list, just to be clear, we still have to put Keller Williams Memorial logo.
The logo has nothing to do with that. That's an addition to whatever you do.
Right.
But you must have one of those DBAs in your advertising.
Thank you.
We'll pass the microphone up here somewhere. Or you've got one there? Thank you. Okay, so again, it's real important that your advertising be perfect. On your websites, social media, everything. You just don't get a chance to not do it properly. Okay, so now we're going to get back to the PowerPoint. So we went through the advertising. Pretty simple. Now we're going to talk about contracts. Question says, when must the option fee be delivered and receipted to the listing agent or seller? There you go. The answer is 3 days within the executed date of the contract. When does the option? Our contracts are all calendar days unless otherwise noted, and the only one that is that provision is in paragraph 5, earnest money. When does the option period end? It ends at 5 p.m. on the last day of the option. Okay. Does it expire at 5:08? Like all the Astro games are at 08? No. So as a buyer's agent, you're the only one that really should be hyper about this. The listing agent and seller could care less that the buyer has the unrestricted right to terminate. They'd probably like it not even to be on the contract. So I'm going to tell you as a point of reference for you, if you are a buyer's agent, don't wait till 4:30 on the last day. And if you do send it at any point in time, you better verify with that agent they received it. That would be doing your best business practice for your buyer. Just don't throw it out there. Because we've had some situations where things were done and it was sent to the wrong email address by one letter. And the buyer lost their unrestricted right to terminate. So you know what I'm saying? You just get verification from them. If they're evasive, which a lot of listing agents tend to not want to respond to you on critical things, the best way is to text them and say, did you get my email? And always send it to the title company at the exact same time that you send it to the seller and per paragraph 21 notices. That's just a good way to always make sure that you do that. Yeah, we need a microphone somewhere. Where is it? There it is on the table.
So you're saying that we send our questions or any of our repairs to the title company at the same time we send it?
No, I didn't say that.
Okay, what were you saying that we need to send to the title company?
Any notice of termination.
Any notice of termination. Okay, thank you.
Mm-hmm. When do the days in the contract begin? The day after the executed date, effective date. What if you go to that page and there is no date that has been applied by the agents? You're in serious trouble. Only the agents apply that date. It says broker. In other words, don't ever let that go. You would have to do an amendment to the contract to establish the effective date if you've already got it receipted at title. That's a serious issue because it removes doubt from the buyer and seller that they've got agents who know what they're doing. That is the most important date on the contract because it triggers when will all parties start performing. Okay? You have to get a microphone. Somebody has one. You can keep that one for this. There's a lady behind you.
Thank you, Marilyn. Just to confirm, any of the two agents, let's say the listing agent missed the date, the execution date, and he was an offer. Buyer sent the offer, the seller accept, execute the contract, but there is no date on the execution date. Can the buyer agent put the date, or has to be the seller agent?
Oh no, it's the agent who has it last, and they don't get to just apply it. They have to give notice of acceptance of contract to the other party. So what would happen if I was a listing agent? Let's just use the real life thing. I'm a listing agent. It's 11 o'clock at night. I can't put an effective date on it because I have to give the notice of acceptance and get consensus with the other agent, then apply the effective date and give a copy immediately. And so a lot of listing agents in the middle of the night will do all these crazy things. Well, that's not following what we're supposed to do. How did that poor buyer know when the contract became effective? They don't without a notice of acceptance of offer being presented by the agent who has it last to the other party.
Okay, I do have a specific case. There was an agent who actually asked me. He was representing the buyer and sent an offer. The offer was accepted. He had written communication that the offer was accepted by the seller, and
He'd have to have a copy of the
No.
contract.
He got an email or a text
No,
message.
That's not,
I
that's
know.
not right.
He received the executed offer, I mean, the contract, like 2 days after it was supposed to be, was signed by the seller, but the listing agent forgot to put the execution date. So he was like, okay, we've been working with this agent. She doesn't really know nothing what to do. My buyer really wants to buy the house. What should I do? How can I move this forward? Because he had to help the other agent a lot. And he's a new agent. And I mean, was really complicated to work with the other agent. Buyer and seller, they want to go forward. But who can put what will be the right way to act on that situation?
Well, if I was an agent who did not get a copy of the signed contract, I have to have proof that everything was done between the parties. If I look at it and the agent who told me we've got a contract didn't put the effective date, I have to put the effective date based on when I got confirmation in writing from my party, period. Because we can't communicate, oh, they said in an email it's great. I don't believe anybody. Either it's in writing or it's not applicable. So just remember, and agents, you get into trouble on this. A lot of you might get a wonderful conversation with the agent who had it last. You're all excited because you have a great contract, but you never get a copy of it, or you'll get a copy, but when you didn't look at the effective date, because you must do that. Both agents are the ones that are in trouble. I won't cut any of them slack. They're both wrong. Because you're not going to give it to your client without making sure everybody knows when the effective date is. So no agent is ever to let the effective date ever be blank. And it doesn't have a darn thing to do with the digital signatures by the buyer and the seller and their date on the digital signature. Not one thing. Notice of acceptance of offer. We're not psychic. How would we know that that contract was effective between the parties? We wouldn't unless we got it in what? In writing, in our possession. So it's real important to do that. What happens if the buyer agent does not get the option fee receipted within the 3 days of execution? This is the saddest day in a buyer's agent's life. Sad, it is. And so that's why I've told you before, as a buyer's agent, you're going to have that option fee money and that earnest money in your possession at time of execution. It's your job to help your buyer in performance in the contract. And that means that you better have them in your possession. I had an agent last week who called me on Friday. She said, well, the buyer mailed it. Who on earth mails an option fee? Does anybody? Absolutely not. Only somebody who doesn't want a termination option. Where's the microphone? Philip, don't talk without a microphone so everybody can hear you at home. Thank you. Or wherever they are in the halls.
Test. So I got one. It was 5 days late. I talked to Michael. He said, and this was 3 years ago. He said, get the agent to verify that they sent it and everything, but inform them that they do not have an option period. And I did
Yeah,
that.
the seller should return it.
And the agent was ripping. She was
Well, the
really
agent
mad.
is not doing their job for their client. You know, this is not hard. This is the first things you learn when you get your license. This is really important. You have a high fiduciary duty of accountability to your client. If you don't help them perform perfectly, it's on you. Nobody reads. And I know this because the agents don't read. So I know the buyers and sellers who maybe have just touched this form for the first time. They don't know what it says. They signed it because they want what? I want the house, or I want to sell the house. It's your duty as the agent to make sure that's all done. And nobody puts anything in the mail if they really want a termination option. No seller should cash it after the days. Nobody can receipt it after the number of days without the seller's written permission, because see, here's what happens. And we have a lot of sellers who don't care about the language in the contract. Time is of the essence on that paragraph. What does that mean? That means if you don't perform, you don't have it. It goes away. It disappears from the contractual ability of the parties. So We've had several situations where sellers got it the next day. The listing agent calls them and saying it wasn't per the contract. They were supposed to have it here yesterday. They did not. They brought it to the office today. How do you want me to proceed? And the seller says, oh, let's just, there are some sellers, I've told you that too about landlords. Sellers and landlords make decisions because they either want to go forward or they want to make it, you know what I'm saying? They'll make those decisions. But we as license holders, we don't make those decisions. Only the seller, and the seller would have to agree in writing to allow something that is not contractually binding anymore. That's the big thing. That's a big duty that the listing agent would have to do. Can a seller extend the time for delivery of the option fee? If the parties mutually agree to it, we can't stop them from doing that. But it would have to be in writing, not in an email, not in smoke signals, and not in text. It would have to be on the contract, maybe in special provisions, but you can't put something in special provisions if it conflicts with the provision in the contract. Paragraph 23 says that it's going to be within 3 days. So the seller and the buyer would have to either have a lawyer address it, or they'd have to have a really good statement that would say that, per paragraph 23, the 3 days have been changed to 5. Whatever that is, it's just a statement. We're allowed to do that. But again, make no mistake, it is, the parties could agree to do that. We've got lots of stupid companies out there, Zillow, Redfish, Red Perch, all these different things, and they have all these addendums, and the buyer's agents are freaking out because they're getting these addendums that override everything in our promulgated form. That's not how it works. We don't touch the promulgated form. We can add, buyers and sellers can add material, facts, or business statements, but if it conflicts with another part of the contract, we have to tell them in writing, okay? That's a serious matter. Somebody, do you have a question? You have to have a microphone. Do you have that? Okay, great.
Okay. My situation, my scenario is that it is the extension of the option period check was lost in the mail, but not by me. I dropped it off. It's receipted and copied that it was receipted. I'm representing the buyer. The sellers mailed it to the seller who lives out of the country.
You mean the listing agent mailed it to the seller?
Yeah.
Uh-huh.
And they lost it. So because I did my part and everything on
Yeah, the
time,
buyer does not have to give another check, period. It was delivered.
they
Period.
didn't get it.
Well, that's their problem, not ours. Once we have it receipted,
Yeah.
we're not in charge of representing that other party and making sure they received it or delivered it and that type of thing. You did your job as a buyer's agent to make sure it was receipted within those 3 days.
Okay.
We've had a scenario where 3 months later, after closing, the sellers are in Colorado and they're unpacking a box. And they find an option fee check. So what do you think they did? That account was closed. They had the nerve to ask the buyer to issue another one. Oh, absolutely not. Any listing agent that doesn't make that seller cash it the day they get it is insane. Get it that day. If they came to the office to pick it up from you as the listing agent, you're going to tell them, go across the street to Chase, Wells Fargo, where you cash that now. Cash it on your way home. And in Houston traffic, it could be, the next month. But you want them to cash it right away. And the reason for this is, do you know how many option fee checks have bounced? A lot. And the good listing agents are the ones who made their sellers cash it right away, and they found that out. Because otherwise, we've had sellers who didn't do that, and their listing agent told them to do it, and they didn't. The buyer terminated based on their termination option. Turns out, it was not a good check. So again, listing agents, you get your sellers, to cash it right away. The moment you give it to them, tell them to cash it.
Marilyn, can you, on the option fee, if you want to extend it to a 5th day, let's say 5 days instead of 3, can that be done through an amendment to the contract or not?
If it's at time of offer and the parties agree to extend it, it's going to be in special provisions.
In special
If you do
provisions,
anything after that contract is executed, the amendment has a paragraph for that.
So we could do it through that after the, okay.
Yeah.
Thank you.
Okay. All right. explain the options the buyer has regarding the third-party financing addendum. Did y'all have enough room? Probably not. And I'm going to tell you, this is the saddest thing, but I say that I'm going to talk about third-party until my last dying breath, and I mean it. I had 19 text messages from one agent yesterday regarding these things. So third party, if you don't understand it, you need to get back into training. That's all I'm going to tell you. Do not use that form and not understand it. Really, that's one of the big things. So here's what I'm going to tell you. Buyer's agents, you're going to tell your buyers, this is all about you, Mr. and Mrs. Buyer only. Only about you. And that means you have to have perfect performance and timely notice. What I mean by that is you have the option, in the event you don't get the terms in paragraph 1 or you're not individually approved, you have to give written notice to the seller within these number of days in paragraph 2A. No ifs, ands, or buts. Time is of the essence on paragraph 2. It's all about you. In the event you get an appraisal and it's not 3 days prior to closing, you're in serious trouble because the contract has changed now. And in 2B, only the lender gets to formally decline property not meeting approval in writing. And you have to do that notice 3 days prior to closing along with the lender's written notice. Otherwise, you've bought it. You will be in default. And your lender can't even approve the property. Big, huge changes this year on March 1st. And if you don't know those changes and you are winging it, you're going to be in serious trouble. You don't ever want to miscue on any of that because time is of the essence on that paragraph. That notice is timely. You can't do it later. Because it's changed where the lender is the only one in third party that can say the property doesn't meet approval. If it doesn't appraise and the lender says, hey, I don't care, I'm going to not decline the property because the buyers are well set. They have assets. They can make up the difference, all these different scenarios. The buyer will not have the ability to terminate. Now, listing agents, here's what you're going to tell the seller. Mr. and Mrs. Seller, you just got an offer on your property after 3,000 days on market. We're real excited. But on this third party, it's not about you at all. You just have to sit and wait to see if the buyer will provide notice or perform, or if the property approves. It's not about you at all. This is only about the buyer and their provisions. And that's how you have to explain it to them when you present your offer to them. This third party is not about the seller. And once sellers really understand third party, they negotiate very differently with the fill in the blanks. They do, because all of a sudden it's been brought to their attention that something is there. So again, a third party is one of those that we have it so often attached to our promulgated forms because most people finance, right? And so you just have to be real clear as a buyer's agent, reviewing that with buyers. And as I said, you're going to tell them this is high performance. You will be on alert the entire time until you pass all of the notice requirements in third party. Yes.
Can the slot where they put in normally there's 21 days, can the buyers put any number of days they want there?
No days in the contract and a fill in the blank can go past the closing date. Okay. So yes, the buyers can put all sorts of values in there. They just can never go past the number of days of the closing date. I prove that nobody reads because when I used to teach the agents in my market center years ago in risk management, I would tell them, you're a buyer's agent. It is your fiduciary duty to always present everything in your buyer's best interest. And when the agents would ask the buyers, how long do you want? Well, I want up to the date of closing. So the agent would kind of count it all out and make sure that they were backed off a little bit because you never know when execution would be. But they put outrageous number of days, 41 days, 43 days, right? Well, I prove that no listing agent really reviews properly for their sellers because when the buyer gave notice per third party and they were well within their number of days, the listing broker fired off, picked up the phone, started yelling and saying, what are y'all teaching over at Keller Williams? I said, how to be a fiduciary. I said, but you're a broker. You absolutely went through this with your seller. So this is not new to you. You knew that at time of offer. And then they hung up on me. Because that's what I would say to any agent. who represents a party. You don't ever get to say, I didn't look at that and review that with my seller. So I proved it. The problem is listing agents look at the prospective offer in a different way rather than really getting down to the heart of the provisions that might hurt their seller by having a prolonged time frame. And that's just two different perspectives. Buyers have one and then sellers have one. And so you really need to make sure that your sellers understand it, what's presented to them, and then ask them, do you think 20 days is too many, or would you like fewer? How would you like to approach this? And I've told you the story. We had a condo in Port Aransas. We sold it before Harvey came in. Now, my husband's a license holder too, and he worked for AT&T for 34 years, and now he works for me, right? So he gets the offer at the same time I do because our listing agent sends it to us. So here I'm looking at all the detail, trying to think about, how this could work, right? And he's already upstairs investigated the buyer who's buying it and what company he owns and all this other stuff. And he yelled down to me, he said, 20 days will never be acceptable for third party, for notice. I said, well, really, 20, and I was trying to be, well, I was always told years ago before I became a license holder, you always make the first offer work. And I've always lived by that. So, and he said, no. He said, Marilyn, he said he's very well set. He either I'll agree to 10 days, the same as the termination option. He said, but nothing longer. I'm thinking, okay. So because he's boss, I went with him, and we countered, and they accepted. Let me tell you what happened. See, this is where this could go two ways. The buyer will either say, I'm not going to go forward with this offer. I don't like the number of days of that. What happened is during the termination option, they amended the contract to close 30 days early. They got approved during the termination option. So it works. I'm just saying there's different perspectives. There's some people who kind of don't want to hardball dates and time frames and stuff. And then there are others that absolutely do. But that's their decision, but they have to know their options. So please don't not give them their options to do that. We did sell it before Harvey. And do you know it didn't have any damage? It was on the 3rd floor in Cinnamon Shore, which is a beautiful development there. Have any of you been up to the coast since then? It is so much cleaner. I've been going to Port Aransas since I was a long time ago. It's when we had to only take the ferry to get over to the island. And there are places we stayed in from the 50s and 60s that had been there until Harvey. And now they're all gone. And so everything that's left, everybody's rebuilding, and it's all clean and all this wonderful stuff. It's amazing how resilient everybody is. Okay, can the seller demand the earnest money if the buyer did not provide notice per third-party financing addendum paragraph 2A and is not individually approved for financing and will not be able to go forward with the contract? Yes or no? Yes, the seller can demand it. The buyers didn't perform per the contract. The problem is, the operative word is demand. Please do not tell your sellers you will get it, or say, they'll release it all. It is a mutual situation. No title company will release earnest money until the parties mutually agree to sign a release. So while your sellers are certainly, looks like their provision is there where they can demand it, everybody can read it, they know. And the problem would be is if you said you'll get it or you're entitled to it. Yes, the contract has a provision, but it doesn't mean they'll get it. It has to be mutually agreed upon in writing by the parties. Otherwise, title will not release it. And I think that's the hardest thing is everybody wants a guarantee, and we never know. Even when the buyers are in default, and everybody knows they're in default, they still want to make a demand on it. And then becomes the civil matter between the parties regarding earnest money. Can the buyer terminate the contract if the property does not appraise for sales price and lender will not decline property approval? Only if they attach the addendum concerning the right to terminate due to lender's appraisal. I know, addendum concerning right to terminate due to lender's appraisal. I call it the appraisal addendum, but Trek chose those words. Yes, per that, if they had paragraph 3 on that addendum done, they have to actually have, there's a big performance. It's within a number of days. They have to have the written appraisal back, and they have to give the notice properly to the sellers on that. You have to get a microphone. Addendum concerning right to terminate due to lender's appraisal. You're welcome.
Okay, the question is, if they don't have the addendum of appraisal, they can still terminate and they will lose the earnest money probably, right? Or
Well,
they
no.
cannot
It's
terminate.
termination means they have a provision per the contract or addendum. Otherwise, they're called default. Termination means to the buyer, I can terminate this contract because I have a provision to terminate and I've given notice properly. But if they don't have everything that's according to the contracts, they don't have the privilege to terminate, it's called default. And if your client is in default, we don't assist people in defaulting on these contracts or breaching contracts. You always advise them in writing to seek legal counsel. Period. In writing. You have to tell them that. Now, which addendum is required if buyer wants an additional option to terminate the contract if property does not appraise to a certain sales price or value? Addendum concerning the right to terminate due to lender's appraisal. There are 3 paragraphs on that form. The third one is the only one that really benefits the buyer in getting an additional provision. One is very strictly used for the seller because they're telling the buyer, you don't get the right to terminate ever based on appraisal. You have to make up the difference, even if it's $200,000. Paragraph 2 is a cap for the buyer. They said, I'm willing to make up this much of a gap, but if it's not within this gap, I get the right to terminate. So the first 2 paragraphs are for the seller predominantly, but the third paragraph is the buyer's additional option that they're given. Yes.
Another question regarding the appraisal. If the third-party financial addendum is an FHA and there is a clause, I don't remember exactly.
It's
the paragraph.
paragraph, yes, it's paragraph 4.
Says that the contract will be, will go through if appraised at certain price, correct?
FHA and VA buyers are never punished if the property doesn't appraise. They don't even have to give notice. Yeah, we all talked about that.
So just to confirm and just to make sure I understand it correctly, if it doesn't appraise and the buyer agent did not supply the addendum, is that correct? They can't get out of the contract.
The lender is the only one that can terminate due to property approval and third party. If
Gotcha.
you don't attach this, the buyer doesn't have an independent option to terminate based on the appraisal. It's all lender required.
So if it wasn't attached and it doesn't appraise,
And if the lender will not decline the property 3 days prior to closing and give you written notification, the buyer gives the notice it's done. Are FHA and VA purchasers required to provide notice if property does not appraise? No, never. What can a seller do if the buyer did not provide the earnest money? What can the seller do if the buyer did not provide the earnest money? Terminate. Paragraph 5 is a new provision, and it's the first time it ever says the seller can terminate. Most of the time it says buyer will be in default, right? But this one did, and when they made that change in our promulgated form, then they had to create the form for notice of seller's termination of contract, because it was the first time they actually literally had the language that the seller could terminate. So they had to have their own form, which they do have. Paragraph 5 is the earnest money. Now, does the seller have to verify independently from the title company that they don't have that earnest money in their possession? Absolutely. They cannot give notice and do that addendum, give that notice to the parties unless they have verified in writing with the escrow officer that they have that buyer. Yes.
one question regarding just this last part. So, if a buyer make an offer is accepted, they never deliver the earnest money. The seller, the only thing the seller can do is terminate the contract, or can actually make the contract go through. I mean, there is a written contract, correct? There is a liability on the buyer who
Right.
actually.
Yeah, it's just a provision that the seller has. They would have to seek legal counsel if they want to pursue a buyer who didn't deposit earnest money, and then it would cost them money to pursue them legally. And like I said, a lot of sellers make a decision because you've got to weigh. Do I go after them and I can't get anything, but I'm going to be paying attorneys? Because attorneys always get paid. And they usually want a retainer, $5,000 or more, to do those type of things. At least that's what we've had the experience with. Is there a termination form for the seller? Yes, please use that. Do not do anything contrary to that. That is a promulgated form. It's new. It was done when they changed paragraph 5. Notice the seller's termination. What happens if the seller took the refrigerator, washer, and dryer, and in MLS they said they would leave? What happens to the sellers? Nothing. Absolutely nothing. MLS does not convey contractually. The listing agent isn't in charge of the buyer, so the buyer's agent is the only one who's going to be in charge of that, and they are always going to put it on a non-realty item addendum. Just because you see something in MLS doesn't mean one thing contractually between the parties. Whose responsibility is it to make sure non-realty item addendum is made a part of the contract? Buyer's agent only. That poor buyer's agent who didn't get the option fee receipted, well, they're crying now because they didn't put all the non-real estate on a termination.
Marilyn, I'm actually working on one right now. The buyer agent is a broker over 20 years, and he sent the non-realty items on an amendment to me last night.
Well,
And I corrected him. I said, we're not under contract yet. You cannot do an amendment.
No, there
you have
you
to
go.
do a non-realty item addendum.
Yeah,
You appreciate it.
once the
bring
contract
him
is
over to
executed,
Keller-Williams.
then you can have amendments. You can't have amendments before you have an executed contract. But we have that a lot from brokers who stand on their own and have been in the business a long time. It's really difficult when you have a party that's on the other side of the transaction being represented by a standalone broker, because you don't have the ability, like everybody here, man, they would have no problem picking up the phone and complaining here. But see, that's the only source. And years ago, we had an ombudsman in every board throughout the state. And then it became too costly, so they deferred it to Texas Realtors. So I'm going to tell you, if you get into those situations and it needs to have just a little clarity for the other side, and we can't seem to get it across, and it's not really our job to tell the other party what's right and what they should be doing, you can contact Texas Realtors, the ombudsman. They will step in, they'll make a friendly little call, they'll just have a little conversation with the other party. But you're not going to believe how many times we get the reports back that the other party never returned the call. So see, they had the same problems we did. We couldn't get through to it. But there is that ability for you. Please don't feel that you don't have some resource that you can at least try and do that. Can the parties negotiate after the termination option has ended? Yes, they can. You can negotiate till the closing if you really have the ability to do that. In a truck complaint and under a civil lawsuit, we had a buyer's agent in one of the operations who, under oath, said that, nope, told the buyer you can't do it. Please don't ever do that. Who gets to tell the buyer yes or no? Sellers only. So that would always be in writing in an amendment, that kind of thing. Yes?
Okay, so in number 17, where the seller didn't leave the fridge, washer, and dryer, I was assuming that they were already in contract. So if they were in contract and the sellers didn't leave that stuff and the buyer had provided a non-realty
Well,
item.
that's not what it said. That's what I'm saying. If the buyer has a non-realty item addendum, the sellers are responsible for bringing them all back.
And so if they took the stuff that was in the non-realty items.
The buyer
as
wouldn't
agreed to,
close. They'd probably
buyer
seek
has the
legal
option of not
counsel, and they'd
closing.
have options. They can consult with their attorney and make that decision. As a listing agent, I'm just going to tell you that is your greatest nightmare. And I always walk through my seller's property before they ever thought they could go to closing. Because see, that's what happens. The poor buyers go through their final walkthrough with their agent and they see things that were not apparent to them before. And all of a sudden they're freaking out. Our goal is to get everybody to closing on something like that. So as a listing agent, I was always there scrutinizing everything. Nothing was worse as a buyer's agent to walk into a property and know that the sellers had not complied with the contract. And here we are down to closing. Everybody's time frame has been accelerated. So make sure your sellers understand that. We've even had sellers who bait and switch because the buyer's agents didn't fill out the non-realty item appropriately. That addendum says serial, make and model, location, color, the whole bit. The failure of you to do it, you should really take a picture of it and attach it to the non-realty item addendum so everybody's real clear. And what happened was it was a beautiful refrigerator, custom refrigerator. Seller put the one that was in the garage in the house, and he said the buyer agent didn't do their job. It was pretty horrible to have somebody that way in the transaction. And the worst part was this buyer's agent, it really stressed her immensely because the sellers did something so unscrupulous. And it was really hard because, see, the form tells you what to do before you fill it out. So it was a buyer's agent miss on something like that. So be real exact like that. It's better for your clients. If a buyer needs to receive the proceeds from a previous sale, does the seller need to know this? You better believe it. Listing agents, no seller is ever going to accept an offer when there is an addendum for the sale of other property without doing their due diligence. On a conditional approval letter, the lender actually has to place that information there for the seller. And we only do conditional approval letters if we're listing agents because pre-approval is nothing. It's just a piece of paper. It's not even worth the paper it's really written on. So just make sure that everybody knows that and it's all part of the contract. The addendum for sale of other property by buyer has an automatic termination. What does that mean? Could you get a microphone in case, because you're the only one who piped up to talk.
Okay, all right, so, okay, so there's a date on the sale of other property addendum that indicates.
Paragraph
as-
A.
Right, as of this date. So if that date passes, then, I mean, if that date goes by, then that's automatically.
Right, and you're right.
It's hard to say it,
Good
but
for you.
I know what it means.
And I had so many people that we did the Race for the Cure for the Susan G. Komen. All of you, I'm sure, bounced back very quickly. It took the rest of the weekend for me. It was, but it was wonderful to see how many people participated for Betty. It really was. It was really good. This automatic termination is something that really gets a lot of buyers agents big time. And what it means is the buyer doesn't even have to give notice. You know how we talked about the notice of buyer's termination of contract, seller's notice? No notice is given, it's automatic. And it's bitten not only buyer's agents, but listing agents too. So what happens on that, in the event the buyer has to extend that, please do that in an amendment. Make sure that if they ever extend the closing date, they extend that. Case in point, the language in paragraph A on this addendum says the buyer must receive the proceeds. Everybody know what proceeds are? Money. So what happens, and it's in bold, here's what happens. Sometimes, unfortunately, buyers and sellers are not happy with each other towards closing. We have that sometimes. And in this case, the seller actually read. The listing agent didn't, but the seller did. So here's what happened. The seller was evidently burned on for sale of other property in previous transactions. So when it came time for him to accept this contract with this addendum, he talked to the lender, got the lender's information, found out where it was closing, all this kind of stuff, right? So here's what happened. The buyer agent is so happy, they call the listing agent. Oh yes, they just closed on their property. We look forward to closing tomorrow, right? So the listing agent's pretty happy too, because she's thinking, I'm going to give good information to the seller. Tells the seller. Seller says, oh, okay, well, I'll see you tomorrow at closing. Well, the seller contacted the escrow officer at the title company where that transaction closed. She said, or he said, did it close today? Oh yeah, it closed. Well, did it fund? Did they get their proceeds? They said, oh no, it'll fund tomorrow. And the seller said, automatic termination says proceeds, and you won't get your proceeds till tomorrow. There are just some parties that actually read these provisions, and we don't need a lawyer to say we know what it means. We saw it. It's pretty clear in that issue. That's why I say as buyer's agents, make sure that's enforceable. Because you always want to, because we've had a buyer's agent who extended closing date, but they didn't extend that date in paragraph A. And everybody understands closing and funding don't occur at the same time sometimes. And, you know, sellers even need to know that too in just normal transactions. But in this one, when it has the automatic termination, it is deadly. And thank you for piping up and answering that. Good for you. Okay. Can a seller have a backup contract? How many? Oh, I'm so glad you said that. I had a class that said as many as the seller wants. And I told them, I said, well, you all have to leave the room now and go into remedial training because you can only have one backup contract. I know you want to be happy about selling the property, but you should only have one contract that's enforceable and then one backup contract that's in place in the event the first one terminates. Okay, great. Does earnest money and option fee get delivered on backup contract when the contract is executed? Oh, does the backup contract addendum need to be a part of the backup contract? Yes, you can't have that contract without that addendum attached. It can't just hang out here. It has to define, this is not a contract in first place. This is the contract waiting to be first place. It's in a backup mode. Does earnest money and option fee get delivered on backup contracts when the contract is executed? Absolutely. And the buyer agents are always calling me, but what if it doesn't go forward? I said, well, your buyer has the unrestricted right to terminate. Get it and get it done and let them have that option, because otherwise in the backup addendum, they have to wait till a date. They've told the seller, look, I'm willing to wait till this date. But let me tell you what happens on backup contracts. You know, you spent 3 days getting this backup contract done for your buyer, right? And what do you think they do? They go to an open house on Saturday. And then you get the call, oh, I found a house I like better. And so you haven't delivered the option fee on that backup contract. That's when the buyer has to stay there until that date. We've had unfortunate circumstances where the buyer agent was so excited they sold their buyer 2 houses. One was on a backup contract, but another one didn't have that. But anyway, what it turned out is that the seller wouldn't let them out unless they kept the earnest money, because the buyer didn't have a provision to terminate. They had not receipted the option fee within 3 days of the backup contract. So that's what's real important. You have to perform perfectly on these things. Otherwise, you might be stuck in there. And of course, the buyers didn't know anything. They were hoping their agent knew all of this. And then somebody just got a little excited going forward without making sure everything was done properly on the backup contract. Yes?
Okay, just to clarify, because the contract itself, it's regular, and it says, a buyer had asked me, and we're very picky on the answer. Want to make sure that I answer correctly. So option period was 10 days, and of course we had a back-off offer, back-off addendum. So basically those 10 days, the option period, like regular contract, correct? Those,
paragraph 23 is in the contract for a backup contract as well.
Exactly. So the question is, they can retract from the contract through the addendum anytime while the seller is actually under contract first with another person, correct? And
I
then they
don't know
have
what you
10 more
mean by
days.
retract.
They can terminate the contract.
Okay, well, let me just tell you, they cannot terminate unless they have paid for the termination option fee with the unrestricted right to terminate.
Considering that, they have paid that, okay? They have the option.
They have to
period.
stay there until that date in that contract, backup contract addendum, unless they have paid their termination option.
Okay, they paid the termination option. And the question is, those 10 days option period that is in the regular contract, those start at the moment that they're actually under contract with this seller, that the first contract went off and that
Yeah,
they're
on the
actually
backup
in it.
contracted addendum, in one of those paragraphs, it's real clear. It says that you will be here in a backup mode until you are notified by the sellers in writing that you are in number one position, and then you have an amended effective date, and all the dates in the contract and addendum go forward from the amended effective date. So it's on the backup contract addendum. Okay, listings. All righty. Let's see if I can. We'll just do it this way. Maybe. No. Well, here we go. Okay. Listing questions. Can we place a property in MLS without a fully signed and completed listing agreement? I'm so glad y'all think that, because it's true. But now let me tell you what's really frightening for you. You submitted to compliance when you submitted the contract, and it's going to close in a couple of days. And all of a sudden, on the listing agreement, we noticed that you never initialed, signed, or dated it. Did you have a listing agreement? Absolutely not. So please, please, please do not fail to do it properly. You don't have a listing unless all parties, this is a bilateral agreement, and so the sellers have to initial, sign, and date everything, and you do too as the agent. To not have that means you don't have a listing. Okay, just want you to know. We've got too many agents that are not being real careful about something like that, and that is pretty sad. Can you take the listing in your name or the brokerage name? Please do so. And hopefully it's one of those DBAs that was up on the Trek website. What if the seller previous terminated a listing agreement? What steps do you need to do prior to listing the property? Right. You want in your possession the copy of the termination of listing that the seller and the previous broker completed. Okay? It can't just be one way. It is a bilateral agreement. As I said, the parties have to agree to it. The reason I say to look at that is because on our notice of termination of the listing, the broker, because Texas Realtors protects the broker's interest, which is your interest, they have a provision that says, oh, I'll terminate it, but you still owe me commission until such and such date. And sometimes that's the expiration date on the listing agreement, okay? And as the new agent who's going to take this listing, you better make sure that seller doesn't owe commission to two brokers. You have to put it on the net sheet. And we've had this happen so many times where Keller Williams agent is the listing agent number 2, and they get it under contract really in short order. And then what appears at the title company very close to closing is the other broker's invoice, their DA, for commission based on the terms. And I'm going to tell you that we have had some listing agents that have done things that are unethical, and I just want to kind of let you know what happens. On the notice, the termination of listing, you really can never go past the expiration date that you have on your original agreement. That's not where you negotiate an extension. Okay, everybody understand that? And what we had is the listing broker number 1. It was supposed to expire November 30th. On November 1st, the owner and the broker number 1 reached the termination of listing. So the seller was real excited about this. You know, he wanted to have the new Keller Williams agent. Well, the next thing you know, within a week or so, it's under contract. When the listing agent number 2, the KW agent, got a copy of the termination of listing, they realized that they had extended it another full year on the date. And even the seller signed it and didn't realize that it wasn't like the year that they were supposed to have it. They did it a whole year. It was very unethical. Unfortunately, we don't get into battles and interfere with other agreements with other brokers. But make no mistake, the seller hired an attorney to go after broker number one. You can't do those things. Do you know what I'm saying? That was unethical. And the listing agent really thought, you know, that it was okay because they got it. You know what I'm saying? But everybody didn't realize the year was a year from now where they broker number one. So you can't do that. So just don't try and do that with the termination. Yes.
If it's on MLS that is terminated, you assume that is correct, that
You don't assume anything. The minute you see termination, you're going to tell the seller, saying, I can't wait for us to have a listing agreement, but I cannot do your net sheet and we can't have an agreement until you give me the termination of listing in writing. Because you have to look at it.
even if it's like 2 months passed already and it's terminated.
That's
on
fine, as
MLS,
long as you look at it and have vetted it and made sure that that seller doesn't owe two brokers, you're going to be okay. But that's what you'd have to do, make sure that that owner doesn't owe two brokers. That's your job as listing agent number 2.
My future seller, she told me that she expressed herself over the phone and that listing agent terminated.
Yeah,
And then I
nothing's
saw it
done
on
verbally.
MLS, but she never sent her anything.
Yeah, that's really a dangerous situation for your owner. Do you know what I'm saying? As I said, we had one where the listing agent number 2 said, she said, oh, found out that they never had a written listing agreement. I said, but it was in MLS? Oh, yeah. Don't know how they did that one. So again, nobody gets to say you're fired. It's how you reach an agreement. You can do it, say you're fired, but the parties have to mutually agree to something in writing. Just changing a status in MLS does not contractually eliminate that seller's risk.
So I need to ask her to ask a termination notice.
Yeah, say, can we get a copy of your termination of listing? If the other agent has put it in an email, I've released you and all this, you're going to save that forever? Because
Okay.
if an agent said that, they have to hold their word, otherwise
So
it
that
isn't
will
a
work
thing.
then for me.
Yeah.
Okay, thanks.
And again, if they do anything different than that, you're going to say, well, I told you we needed to do all of those steps.
I have another question with.
I'm sorry, they can't hear you.
I have a potential seller, and he has his listing listed with a relative. So it's a nightmare. I haven't touched it, and I told him we can't really talk until you all get it terminated because it's not selling, been on the market for forever.
Did the seller contact you?
Yes, he did. He called.
You can visit with him if you didn't initiate it.
No, I didn't initiate it.
Yeah, you can visit with him. The only thing you couldn't do is assist him in terminating the agreement.
Okay.
You could say, when you are free to list with me, I would love to have your business and earn it.
That's basically what I said, but the deal is he doesn't apparently have a listing agreement with his relative. So if they put a termination agreement in place of a listing agreement that didn't exist, is the termination agreement still valid?
Well, first off, you don't have a listing that's not in writing. You violated MLS rules.
Yeah.
So they can do it by email. You're going to keep that email because that's the agent's word. And as I just said, if an agent writes something, it better be true always and ever.
Okay, thank you.
Is a seller that never lived in the property exempt from providing a seller's disclosure? No. Lordy, if I didn't hear that once, I heard it 3 times last week. By agents who know a lot better than that. I cannot believe that. We even had a situation where the listing agent was the owner. I've never lived there. I don't have to complete it. I cannot imagine how a license holder could ever utter those words and not know something better than that. Yes.
Quick question. If somebody in agent remarks on the MLS stated, I just read that the other day, stated that there is no seller disclosure and there is not going to be provided. It's actually legal to set that on the MLS as agent remarks?
Only if that owner was exempt under the Texas Property Code 5.008, and there are only 11 exemptions, never having lived in the property, is not one of them. Being an investor is not one of them. It's a very narrow interpretation. So they don't get to do that unless they have a provision from Texas Property Code that exempts the seller.
And if I have a buyer that is interested on that property, what documentation should I ask instead of the seller disclosure? How can I?
Well, what you're going to do is advise the buyer prior to offer. The seller is not complying with the law. They are an investor. In fact, they're a flipper. And so they are required by Texas Property Code to provide it to you. How do you want me to proceed? Here's what they normally should have provided you. You give them a copy of the Texas Association of Realtors seller's disclosure, and then your buyer will put in writing, oh, I don't care, or whatever. If they want it completed, you're going to ask them to complete it. We have this happening too much in this town, and they're flooded properties. It is a big target here, folks. And any agent, both a buyer's agent or a listing agent that's involved in this type of thing, buyer's agents, you just have to have everything proved in writing that you advised your buyer properly before offer, and then let them make a stupid decision. If they go forward, it's stupid. Because we have more issues where workmanlike quality of work was not done by the flippers. And as a buyer's agent, you're going to be in trouble for that because you have a higher liability and a fiduciary duty to a buyer. Okay, now we're going to talk about offer situations. Verbal offers. Do sellers need to know about those too? Yes. And how do they need to know about them? In writing. You're going to put in an email, I just got this crazy call from an investor. They want to offer you $250,000 less for your property. You're going to put it in writing to your poor sellers that you just got this call. And you're going to present it to them and say, well, how do you want me to handle it? In the event your seller responds with profane language, do not repeat that. Because that's what we had an agent do. They actually forward over what the seller thought of that crazy verbal offer. So please don't do that. In your very sweet manner, be able to present that the seller will decline from responding to that verbal offer. Because they're not going to respond other than put it in writing, right? That's the only thing they would ever respond, put it in writing. Can a buyer or seller withdraw their offer or their counter offer? Yes, and there's a form for that. Notice of withdrawal of offer. Well, we have some agents that don't even know about that form. But what concerns me a little bit more is agents didn't know that they had an offer or counter offer going on. Listing agents in particular, they don't understand. When the other party presents a written offer, right? You talk to your seller says, well, tell them if they change the closing date and the sales price, I'll do it. That's a counter. It's a verbal, but it's counter. Your seller doesn't get to go to the next offer that comes in 10 minutes later that's $20,000 more without withdrawing that counter offer that was verbal, that was passed through you. Okay, so be real careful about that. We've had so many listing agents that got into trouble because they'd been countering terms for, one of them was almost 2 weeks. And then what happened was the seller got a better offer and the seller signed offer number 2 as a contract, but they'd been negotiating for 2 weeks to this other offer. Listing agents, serious trouble, serious trouble. Can a buyer or seller withdraw their offer if all parties have signed the contract? Absolutely not. You have an executed contract. You don't have an offer. Please, please, please be careful. Now, I'm going to tell you what gets you in trouble as a listing agent. And don't think that this hasn't happened, because it has. The seller is real excited about their offer, right? So the seller says, well, I just want to change the closing date, and I just want to do this. And so the listing agent says, instead of it being a true counter, which is what it is back to the buyer, no seller should sign anything, initial at the bottom of the page, sign and date a contract, unless they know everybody's in what? Agreement. So this listing agent had the seller strike through and initial at the bottom, sign that thing, send it over to the other party. You're in serious trouble because somebody could go before a judge and say, hey, the parties have signed the contract. These other things, they'll deem if they are administrative, clerical, or whatever, or substantive. So again, listing agents, be very careful. Your seller is never going to put their signature on an offer they're going to make it a contract. They're going to see all the terms were accepted by the other party. And there is that form, notice of withdrawal of offer and counter offer. It's used with landlords, tenants, buyers, and sellers. So remember that, because everybody should be able to withdraw their offer unless it's executed and all parties have signed it. Who places the executed date on the contract? The last agent that has it, when they confirm that everything has been initialed, signed properly, everything's filled in, there's nothing that's missing on something like that. And then they have to give notice of acceptance of the offer to the other party. Again, I made a comment earlier about an agent at 11 o'clock at night sending it over with an executed date. No, that's not how it works, because the next morning when the buyer agent opens it, that's the first time they got a notice, and they can't go to their own buyer and say, hey, we have an effective contract, but they said it was the day before. Well, no, that's not how it works. The buyers have to be treated fairly on this, and that has to receive notice. The buyer has to know, here it is in writing, here's our effective date today, we just got notice. Buyer's agents, you get that cleared up right away. You don't let it go to title until you get that true effective date for the parties on it. That's really what you need to do. And listing agents is the same, goes for you if you're not the agent who has it last. If the seller provides the seller's invitation to resubmit to a buyer, is that a counter to the buyer? Absolutely not. And I love it because it says so on the form. Okay, please, that's so important on something like that. That keeps listing agents out of trouble, to be real honest, that form, because the seller has to sign it. So it's not the agent talking. Do you know what I'm saying? That's why listing agents, that should be your best form. And I love sellers who say, oh, it's just this one thing. Yes, but let me tell you what's going to happen. If you counter this party and then we get a better offer, you can't go to this better offer until you have successfully withdrawn this other counter offer. So sellers have to know this process a little bit so that they kind of understand what's going on. In a multiple offer situation, does the listing agent need to tell all parties they are in a multiple offer situation? Yes. We take the code of ethics.
Can I ask a question?
Okay.
On number 34, so if you send the invitation to submit to a buyer a new offer, so if you get an offer from somebody else, because this is not a true counter offer.
It isn't a counter offer.
It's not.
No.
So if you accept, if you have another offer the
That's
same
fine.
day,
You're free to do
go-
that.
you can-
It
you are
says it
free.
on the form.
Okay.
I love that because the buyers will read it exactly what it says. So multiple offer situations get listing agents into trouble, and it can include the code of ethics. That's what is the big problem for you on something like that. So just remember that no matter what the seller says, you're not going to do anything contrary to abiding by the code of ethics, because that's what you're bound to on something like that. Okay, and the next one is intermediary.
Excuse me, Marilyn.
Mhm.
Before we go on, may I ask a question about the previous?
Uh-huh.
On the seller's invitation, are we allowed to put a date on there? Well, not a date, but is it advised not to put an amount like more favorably on the price point?
Yeah.
Is it advised to put
The
this?
seller gets to make the determination what they will say to the buyer. Look, if you resubmit a new offer to me with these terms, I might consider them
Okay.
more favorably.
So a price point actually could be one of those terms.
It could
It's
be,
advisable.
and it could be based upon what the seller has received as other offers and stuff like that. The same, say you're in a multiple offer situation and you've got 10 parties who've submitted an offer and the seller wants to send an invitation to each one. Each one will be different based upon the offer that the seller received from that party. It doesn't have to be a standard one that everybody has to receive the same thing, because everybody's offer is different. All these different parts of it. So the seller certainly has the ability to do that. I'm so sorry we're keeping you up here, Philip, but we'll but we'll work on that. Okay, intermediary. This is one of the situations that I have talked about it since 2008. And the reason for that is because the the requirements by law are very set what the broker can do. Years ago, there was this thing called dual agency. And I never understood it as a license holder because it didn't seem right. Here I've been telling this buyer that I've been representing and giving them good advice and being a fiduciary, and then overnight, I'm no longer a fiduciary. So dual agency was never a mechanism that made any sense to me. It just didn't make sense. Why would that turn off overnight? And so intermediary is one of those things you have to have it perfectly done, perfectly timed, and it can only be in writing. There is no such thing as, oh, I discussed that with them. No, it's in writing only what you do. So broker requires intermediary with appointments only. So how many agents are in the transaction? 2, absolutely. Because the broker is never going to say, oh, Mr. and Mrs. Seller, you need an agent, but you don't, prospect buyer. We don't do that because we'll end our industry. I have never understood how an agent could turn to a party not represented and saying, that's okay, my seller has representation, but you don't need it. Does that make sense? Not if you want to be in this business and have an industry for very long. Everybody deserves representation. And because of social media, the internet and everything, everybody thinks, oh, I'm going to be able to get the listing agent's commission if I don't have anybody representing me. But the liability for a listing agent to have a customer in the transaction is so unbelievable. So again, I'm not saying that there's some parties that couldn't represent themselves. Even lawyers who represent themselves don't know how to count. It is. I know. I've been in depositions and the plaintiff attorney will say all these things and I'll look over at our attorney and go, well, he doesn't know how to count. And so we have to make sure that's real clear. So again, we believe that everybody needs representation. When does the intermediary relationship notice get executed with appointments? Here's what you're going to do, listing agents. You're going to be the last bastion. If the buyer agent didn't provide it, you're going to say, hey, before this offer is presented, I need you to get this intermediary relationship notice completed and signed by your buyer. Get it over. As a listing agent, the minute you get it, you get your sellers to sign it, showing the 2 appointments, and you send it back to the other party right before you even negotiate the offer. That's how it goes, okay? Just want to make sure everybody understands that. Does the listing agent need to verify that the buyer agent has a signed buyer-tenant agreement allowing intermediary prior to execution of the contract? Yes. You betcha. Oh, it's very easy. Listing agent. Oh, this is really nice that you presented this offer. I need to see that you have your signed buyer-tenant agreement allowing intermediary. If they say, well, I'm not going to present it to you, but they put in an email that they have it, they better not lie. Okay, agents don't get to lie. Everybody understand that? When it comes to all of this, you better put it in writing and be truthful about it.
So I have a question too, along that same line before I forget what it is. Go ahead.
No, you go ahead. I lost my train of thought. That's no fun. Okay, I'm sorry. I got it back. Okay, so I was in a transaction where the buyer agent, I was the listing agent, the buyer agent joined our firm without telling me. So how would I as soon as I found out that she joined my firm, because she didn't tell me.
Well, it's on page 9 of the offer.
No, I realized that, but she had submitted a contract to me with her old.
The offer?
Yes.
Okay.
With her old realtor, where she had her broker, where she had her license at, and she never told me, oh, by the way, I joined, and I'm like,
yeah,
okay.
That's it. That is horrible. That's
so,
unfortunate.
I always had, Michael got involved and so forth, but it was like, oh my God, why wouldn't you tell the agent you're with, hey, by the way,
well, the information that you have on page 9 better be true and correct.
Well, and I was on vacation when she joined our firm, so it wasn't until I got back, and then it hit me. I'm like,
but see, the worst part is the other broker is going to get the commission.
She's crazy. Okay.
But I mean, it's what it is. That kind of thing. That broker information has got to be accurate.
And if you change during the transaction,
If it was after the executed contract, I'll be real honest, there's no broker that will release it.
okay.
That's the problem. Do you know what I'm saying?
No,
Because
I
it's
do know what
on
you're
there
saying. I've
at
just
the
never
time
had
of
a situation
execution.
happen like that before.
Yeah. Some brokerages are not real good on intermediary in this town, and the reason I say that is because Trek every year publishes the top complaints for this region, and intermediary is right up there. It's almost number one. How misused it is and not appropriately handled. So that is unfortunate, but unfortunately, the other broker would be due the commission. I'm just going to tell you two things. Check out Trek if you get an offer from another party. Check out and see what their status is on Trek. Do not go to HAR. That is not accurate. Yeah, because we have more situations where the other agent's license is expired, which is really deadly because you can't do that. You know, you can't, you have to have an active real estate license. Everybody understand that to engage in real estate activities, right? Yeah, you'd think so. But again, that's for listing agents, please, please, please do that. Do it before your seller agrees to it. If you found that the agent was expired or inactive, you're going to contact their broker immediately and ask how the broker wants to handle it. The broker owns all the buyer tenant agreements and listing agreements, and they can easily appoint somebody instead of the agent that's not in an active status on something like that. But please, please check it as a listing agent. Yes?
Okay, my question was, why would the buyer's agent refuse to provide the copy confirming the relationship?
Well, I'm going to tell you, these are private documents, and even
Yes,
though it's the
right,
same
right,
broker,
right.
you know, he could go and Michael could verify it for him, you know, and tell you, yes, they have a signed buyer tenant agreement.
Okay.
But I don't, you know, some agents saying they may have certain provisions in that agreement that
Okay.
they don't want the listing agent. The veil of intermediary can never be pierced.
Right.
So the best way is to get verification in writing. You do have a signed buyer tenant agreement with intermediary.
With an email.
With an email, because any agent who lies, it's over. They don't get to practice real estate any longer.
Okay, then my next question is, following what you just said, what if you check Trek and it's not the agent that's showing their license inactive, it's actually the brokerage?
That's
Especially
even-
if it's a small brokerage. I had like 3 of those like last week.
Yeah, and you know, the problem is you cannot go forward with that because their license, in fact, here's what happened. Years and years ago, Trek gave, if a broker suddenly died, they gave this like, not intermission, but it was like the suspended time, you need to get your ducks in a row. Today, there has to be in writing the broker ascension. The moment this broker, something happens to him, this other broker ascends in it. And those are in their articles of corporation. And so they have to have it in place now. Trek requires that because that's part of it, because things do happen like that. But the sad part is that buyer agent has to know, look, your broker doesn't have an active license. You need to get with somebody immediately before we submit this offer so that you can resubmit the offer under an active brokerage. Oh, by the way, Michael's here today. Would you like to come visit and talk to him? Yeah, that's really sad. As I said, years ago, it was differently handled. Today, they want you to have in writing the ascension of authority as far as the broker who will come in the stead on something like that. Okay.
I have another question, just
Uh-huh.
one last, according to this, according to the buyer agreement that we can request, but we can have an email saying that the agent has a buyer agreement with the client, correct? Let's see in the future, you talking to the buyer just by curiosity, you find out that actually they did not and the agent lied. And on the MLS, you said sub-agent 0, agent 3%. Can you get that money back? Can you actually fight that?
You're going to
and
go to
somehow-
your broker and get this settled. Any agent that causes that issue, the broker needs to handle that, and something like that. As I said, anybody, if an agent puts something in writing and says it has to be true and correct, they can't lie. That's just, bottom line is they can't do that on something like that. Can you appoint yourself to both the owner and the prospect? Oh, really? Agents have done it, but you cannot do it. Yeah, no, you can't. It has to be two agents. Remember how we talked about that with appointments? We've got lots of agents who don't know what the form is and have never read it and misuse it. I'm involved in a lawsuit right now, and the listing agent appointed themselves to represent their owner, which they had a listing agreement, and the prospect. So I told her, I said I would have to take a buzzsaw and slice you in two. What were you thinking? And so I read the form to her, because this is really serious. They're just going to add a bunch of zeros in this lawsuit once they realize this person didn't know what they were doing. And the broker is ultimately responsible for them not doing it. And this is not a new agent. That's what bothered me more. And she sits in the front row of my training. There was a disconnect. It was called, they wanted the commission. It is not about the money that's already taken care of in paragraph 5 of the listing agreement. It is all the listing broker's commission. We just say we'll cooperate in another paragraph later on in the event there's another broker. But that agent was thinking about money. And there is no way out when you misuse that form, especially when the form tells you exactly how to use the form and what has to be done. So be very careful. As I said, if there is no intermediary and the listing agent is only representing the seller, what is the buyer? A customer. And customers are always right. Yes, because it's their perception, right? They're going to say, well, that listing agent didn't treat me fairly because they knew all this and I didn't, those kinds of things. But we're able to have customers. We don't have a fiduciary duty. We have a huge duty of obligation to treat them fairly, of course, meaning honestly. That's our code of ethics that we take. We represent the seller's best interest. But that doesn't mean that we're not fair to the other party. It's just, here's what I'm going to tell you as a listing agent. The minute they ask you a question that would only be afforded by somebody who represented the buyer, in other words, they're asking your opinions and advice, now I know you wanted all this commission, but it has been revealed to me that you don't have the ability to represent yourself because you keep asking me everything about opinions and advice, and I told you I don't represent you. So now I'm going to have the broker step in, and the broker is going to appoint somebody to represent you. You have to step in as a listing agent and do the right thing. And it's not about money. They're thinking it's about money because they want to get into your pocket. So don't be quick to negotiate away any compensation here, folks, because it is really about representation. And there always could be that issue that could be revealed to you after you have an executed contract. Yes?
Yes, regarding a lot for sale, if I have a lot listing and a buyer comes to me and I always ask, are you being represented? And I also get it in writing, and they say, no, I choose to do this on my own because I'm a seasoned buyer, I'm a builder. But then you know that he has an agent listing a property of his. So obviously they might have
builders, I think, would be able to represent themselves.
Okay. So, and simply because he has an agent who is
And
representing,
they
the
does
listing
not
doesn't
extend them to
interfere
that
with the other-
transaction.
Okay.
Yeah.
Okay, thank you.
You have to be very sure that you never veer out of your representation for the party. She just described something. This builder comes to her because she's the listing agent for the lot, but this builder has maybe another agent representing him in the sale of a property. They're two different types of things. You don't have agency conveyed to you for anything ever you're going to do in real estate. Builders do have the ability to have a little bit of knowledge, unless they just name themselves a builder today. They should be able to transact this. I'm not saying there won't be issues that they might not know how to count, but a builder could represent themselves on something like that. Courts do not view those that represent themselves, that have knowledge, and like builders or investors who have portfolios, they don't really consider them the typical buyer that could be looking to be an owner occupant. You know, that's just, they don't look at them in the same prism that they do to a buyer who is acquiring the property. They're thinking, you know, you've done this before. Why would you be complaining about, you know better, kind of thing, that type of thing. Now, I'm going to give you a little bonus question here. Who earns all the commission, bonuses, fees, whatever in a transaction? Yay, good for you. And the reason I bring that up is from time to time, it really amazes me how the agents put in their agreements that there will be this transaction fee or some fee. No agent gets to have anything in their name given to them by the other party. It's all given to Keller Williams and handled according to whatever your agreement is with compensation. But agents, they just don't think that way sometimes because they are the ones who are procuring the business. But in the state of Texas, licensure for real estate is very, very well funded. That says the only one who owns the contracts, broker. Only one who owns all the listing agreements, broker. Only one who owns buyer tenant agreements, the broker. Case in point, if I left Keller Williams and went next door to XYZ and I want to take all my buyers that are under contract right now, can I do that? No. Absolutely not. And for years and years, agents really felt, no, you know, I'm under contract with these sellers. I can do this. Yes, if you take your listing with you, but once it becomes a contract, who owns the contract? The broker that's on the contract. That's why I said that other broker, as that was deadly because that is under that other broker, not under Keller Williams. Page 9 is not a part of the contract. It is broker information, and you know, you can change that. It's not something that is contractually binding. You would want clarity though, who is on the other side of the transaction. That's why I say, as a listing agent, please check them out at TREC. With today's ability to have the broker go in and send an invite and the other party accepts it, you know, it's a very different process than when we drop faxes and send them up to TREC, and then TREC would have to update the system accordingly on stuff like that, on transfers of those type of things. Okay, did everybody make 100? Yep. Yay, good. Now, next month, and y'all better listen up and this room better be filled. We're going to talk about leases. Because I couldn't put 1,000 questions on here because you're going to have almost as many as for the contract itself, because we have under the change of provisions regarding what landlords are bound to, and we had some changes in the lease this year. A lot of landlords didn't know that. And so there's a codicil to the, there's an addendum to the Landlord and Tenant Guide by Texas A&M Real Estate. I'll give you that link for that. But we really need to be better about our lease listings, about making sure we don't step out of the boundaries. I have agents all the time. I just want to know for my benefit. Really? I know how much you talk. You're going to go back to your landlord and tell them how to be a landlord. I really worry about that. Seriously worry about that. And tenant agents, oh my Lord, that process is bigger than, you know, a tornado. It comes in and touches down, and you've got to have everything perfect in a very short period of time, because more people are going to contact you today. I need to be in one by Thursday. You know what I'm saying? That's how it's just a very different process. So we're going to have a little benchmark self-evaluation for leases by listing, as well as when you represent tenants. Are you excited? Oh, yes. You did? Well, good. I'll tell you, one of the agents had told me, they said, you know, Marilyn, I've been to Ignite, I've done Bold and all these, but I kind of need like a checklist to see how am I doing. And that's what started this whole thing. It just helps you. For new agents, you're looking at it and you found out information that people who've been practicing don't know. You know what I'm saying? So from time to time, we have to do that. My biggest concern is the broker has to be able to prove to TREC, I assisted the agents in understanding where they needed more help It's up to them to seek out that help. Do you know what I'm saying? We don't ever touch a document, get into a situation, unless we absolutely have been there before and we really know with 100% certainty, this is the best way for me to proceed for my client. You always have to stop and evaluate that. I had an agent last week that got a lawsuit. And so I asked for what, of course, I need to know the loop name so I can go in and check everything. The agent turned it in after it had closed. So after we had a lot of conversations about things that will come up, they didn't call me back once, but 3 times that evening, kept calling me. And I said, are these transactions that have already been executed contracts? Well, we're closing in a few days. That's not when you call and talk to me about it. You know what I'm saying? Timing is important. It's prior to doing those things. Because in this instance, you can establish a history that the agent didn't seek help first. Do you know what I'm saying? And I don't want you to be caught in that position. You're the only one that's going to be in trouble. Your broker has certainly identified the policies, done all these things, people in place, but you don't want to ever be caught, well, I didn't ask. I had one agent call me and she said, well, they're always so busy. I said, did you contact them? No. And they were truthful. They said they hadn't. Well, that's on them. Do you see what we just don't know when you need help until you seek for help. You do have to ask. And anybody who knows me knows that I have a great passion in what I do, because I have had to stand next to agents when they take the oath in a court and have to give testimony. I've listened to everything that they've been accused of by the other party that's making all this stuff up so they can get money from us. So I'm real serious about this. I don't want you to be ever caught in that position, and the best way is to not go somewhere and do something unless you have really 100% certainty that this is the way to do. Everybody understand? Go Astros. Yes. Yeah. All right. You keep it. No, you don't turn it in. It's just for you.